basically, I am basically an advocate. The advocate turned academician. I started my practice soon after my LLM course for over the 7 years. After 7 years of my practice as an advocate, I switched over to the teaching. Now I am, the working at the Department of Law as an associate professor. The topic which has been assigned to me for discussion is human rights enforcement mechanism. Human rights enforcement mechanism. Before going to discuss human rights enforcement mechanism, I would like to devote this hour or 1 hour to throw light about comparative law, comparative human rights laws with reference to US, UK, Canada. The second hour, I will focus on human rights enforcement mechanism in India. As a student of a comparative law, I love to teach the American law, in particular American legal system or American constitution law, Canadian constitution law, and UK constitution law. I have hardly taught the Indian the constitution law. So far as human enforcement of human rights is concerned, how the Constitution of US has incorporated the human rights in the Constitution. If you trace the history of human rights, you do come across with Magna Carta of 1215, the birth certificate of human rights, or a fundamental document which lays down bedrock principle of the human rights. You do come across with important rights in the Magna Carta of 1215. That is the first document. The prior to that, there was no written document which assured the human rights. For the first time, the Magna Carta guaranteed the fundamental liberties, fundamental human rights of the individuals. Of course, there is a lot of the debate over the document, whether it guaranteed rights to common man or to nobles or feudal class of the England. However, as a student of law, I can say that the Magna Carta guaranteed the fundamental human freedoms. Fundamental are the basic rights of the individuals, in particular, right to life, right against arbitrary arrest and the detention, and assuring of the rule of law. Assuring of the rule of law. The second document, the second event which led to the emergence of the human rights is Petition of Rights of 1628. Petition of Rights of 1628, wherein a speaker of English Parliament wrote a letter to the king, drawing his attention that the promises which were mentioned in the Magna Carta were grossly violated by the king. Therefore, the English Parliament demanded the king or the British Crown that the Magna Carta should be respected by the king. As a result of this, the Petition for Rights of 1628 was accepted by the king by observing that he would respect the promises which were mentioned in the Magna Carta for 1215. Again, the promises which are mentioned in the Magna Carta and assurance given by the king in the British rights were grossly violated by the king and the authorities of the state. Therefore, United Kingdom, they witnessed a revolution demanding the Bill of Rights, demanding, the basic rights of the individuals. So this war went on more than 40 years, from 1640s to 1618. Ultimately, the British Crown accepted the Bill of Rights, English Bill of Rights of 1688. 1688. That's the first written Bill of Rights. The first written the Bill of Rights, wherein the fundamental liberties were guaranteed. Fundamental liberties were, assured by the king, and it recognized the freedom of religion, or in other words, what you call concept of secularism. Secularism was, recognized by the English Bill of Rights. Freedom of speech was also recognized by the English Bill of Rights. Right against arbitrary arrest and detention was also recognized by the English Bill of Rights. Likewise, there are a number of other rights guaranteed by English Bill of Rights of 1688. 1688. What happened after that? The British, the king or the queen did not respect even the Bill of Rights. The asserting that the supremacy, king used to assert that he was supreme and denied, the basic rights of the individuals, or what you call the natural rights of the individuals. And again, the English Parliament passed an enactment, what is known as Act of Settlement of 1701, 1701, wherein some of the rights were, recognized by the English, the Parliament. The English the Parliament. This document, recognized the parliamentary democracy, or what you call, the constitutional, the monarchy. Thereafter, you do come across with, the theories, the theory of a social contract, which was depicted by three revolutionary thinkers, Hobbes, Locke, and Rousseau. So here, according to this, the philosophers or revolutionary thinkers, Hobbes and Locke and Rousseau, there was the contract wherein the people surrendered their liberties to the one who was mighty in safeguarding the rights of the individuals. So the people surrender their liberties. In return, the mightiest man assured for the protection of life, liberty, and property for the individuals. That is social contract, the theory. So this theory is the basis for guaranteeing of life, liberty, and property. Of course, there is a lot of debate over, or the theory of a social contract, or the philosophy of a social contract, whereas one argues that, that there was, the social contract, the reasons were different. The reasons were different according to Hobbes and Locke. Rousseau, defines the contract social theory from a new perception, the focusing on the element of a general theory, or the theory or collective theories. However, the social contract theory laid the foundation for claiming natural rights of individuals. Natural rights of the individuals, in particular, life, liberty, and property. Rousseau has some more the rights, the freedom of assembly, association, freedom of association, the movement, residence, and so on, and the freedom of speech, and so on. The social contract theory inspired the leaders of the America and European world to demand natural rights. Demand the natural rights. So this social contract theory, they created a sense of a nationalism among the leaders of the America and the European, the worlds are European, the continents. The ultimately, the America started war for the independence. War for independence. In 1776, and proclaimed the independence. The America, they established confederation form of a government in the beginning. The later it was replaced by the federalism. The present Constitution of the United States, or the original, the Constitution of the United States, is silent about Bill of Rights. Silent about the Bill of Rights. In fact, it comprises only 7 articles. The focusing on the distribution of legislative powers, administrative powers, and judicial powers, between the 2 levels of the government, the federal government and state governments. And it was silent about the written Bill of Rights, or written, the fundamental, the rights. The 2 years after adoption of the Constitution of the United States in 1789, the American Constitution was amended and included in it American Bill of Rights in 1791. 1791. So the American Bill of Rights comprises 10 amendments, guaranteeing of basic rights of individuals, guaranteeing of the fundamental liberties of individuals, or what you call the human rights of individuals. Human rights of the individuals. The first amendment to the Constitution of the US guarantees freedom of religion, a human right. Freedom of speech or press. Freedom of assembly. Freedom to petition the government. Petition the government. So there are 4 fundamental liberties guaranteed by the first amendment to the Constitution, or in other words, the American Bill of Rights. Freedom of religion, freedom of speech, freedom of assembly, and right to petition the government the government seeking redressal of the grievances. Seeking redressal of the grievances. The second amendment guarantees right to keep arms and weapons. So right to keep arms and weapons is a fundamental liberty of Americans. Right to keep arms. You can keep arms and the weapons. And the state or the government cannot restrict, it cannot take away your freedom, your right to keep arms and the weapons, because it is a fundamental liberty of the individuals, the fundamental liberty of the Americans. So it is your freedom to keep arms and weapons as a self-defense. As the self-defense. Very important, the liberty for the Americans. You don't find the liberty anywhere in any of the constitution of the world, including India. You don't find it. You don't find right to keep arms as a fundamental right, even in the constitution of the UK or Canada or Australia or any other countries. Whereas the American Bill of Rights recognizes that you have a right to keep the arms and weapon. This is for self-defense, not for killing others. not for committing any crime, not for indulging in any violence. So you can keep, all the arms and weapons in order to defend yourself, your family members, and defend the property. It cannot be misused by the individuals. It cannot be misused it cannot be used for committing, the violence or the offenses. Third Amendment guarantees right against quartering of the soldiers. The prior to, the American Bill of Rights, soldiers had absolute liberty to take away your accommodation or to occupy your residential purpose without your consent, without your will. If the army thinks that, the soldiers think that they need your residential property, they can vacate you. And they could accommodate, they could stay in your residential property without your will or the consent. So the fourth American Bill of Rights, the fourth amendment to the Constitution of the US guarantees right against quartering of your house by the armies or military personnel. So the soldiers cannot, forcefully they take away your residential property. Soldiers cannot vacate you. They're saying that your housing property is required for defense purpose. Your housing property is required for maintaining of, or protecting, of the country. The fourth amendment to the Constitution of the US guarantees right against unreasonable search and seizure. Unreasonable search and seizure. The state cannot search you. The state cannot, conduct search and seizure arbitrarily or unreasonably. If the police agency wants to conduct search and seizure, it should have justifiable reasons. It should have obtained the warrant from the magistrate. Then only the police agency has the power to search and seize any, the property for the purpose of the investigation. So you have a right against unreasonable search and the seizure by the police agency or investigation agency. The most important right of the individuals. The most important right are the human right, the basic right, the basic liberty of the individuals. And fifth amendment guarantees right to life. Life, liberty, and property. So right to life and liberty cannot be taken away without a due process of law. Without a due process of law. This is the very important right of an individual, right to life, liberty. The property cannot be deprived without complying with the requirement of a due process of law. If the state has to deprive your right to life, liberty, or the property, it has to comply with the due process of law. It has to comply with the process of law. Most important liberty of the individuals. Right to life, liberty, or the property cannot be deprived without the due process of law. Sixth Amendment guarantees rights of the accused. Speedy trial, legal counsel, right to be informed of the accusation or the allegation, jury trial, and so on. Seventh Amendment to the Constitution of the US guarantees right to jury trial. Right to the jury trial and, the jury trial and the public trial. So you can claim the jury trial as a fundamental liberty guaranteed by the Bill of Rights. The Bill of Rights. Eighth Amendment guarantees right against unusual and cruel, the punishment. Right against the unusual and cruel are the punishment. So the first 8 amendments guarantee specific rights of the individuals, specific rights like freedom of speech, freedom of religion, freedom of assembly, or freedom to keep arms and ammunition, arms and the weapons, or right against the quartering of, the quartering by the soldiers, right to life, liberty, or the property, or right against double jeopardy, right against self-incrimination, right to seek legal assistance, right to the jury trial, right against arbitrary arrest and the detention, and the so on. 9th Amendment, the provides that are the safeguards rights retained by the people, rights retained by the people. This is unenumerated rights. So merely because rights are enumerated in the first 8th Amendment, it does not mean that you do not enjoy any other rights. You have unenumerated rights. That is rights retained by the people. Right to marriage, right to work, right to employment, right of the movement, right to the travel, the privacy right, and other rights retained by the people. This is unenumerated. Whatever the rights are the rights which are not covered by the first 8 amendments, are the protected by the 9th Amendment to the Constitution of the US. And the 10th Amendment, the provides for residuary power. The state governments have the residuary powers for making any legislation for the protection of the rights and the liberties of the individuals, rights and liberties of the individuals. So this is how the American Constitution has respected the fundamental liberties or fundamental human rights of the individuals. If you read the first 10th Amendment, you do come across with the fundamental human freedoms, the basic liberties of the individuals, basic liberties of the individuals. Whereas in Canada, the Canadian Constitution was, they adopted or brought into force in 1867, 1867. In fact, the Canadian Constitution was not adopted by Canadians. Rather, it was enacted by English Parliament. English Parliament. The normally, when we got or when we attained the independence, we dropped the Constitution. And we do not ask the foreigners or foreign parliaments to enact the Constitution for us. Whereas in Canada, the Canadian Act, what you call British North America Act of 1867, was enacted by English Parliament. And it was silent about the fundamental liberties of individuals, silent about basic rights of the Canadians. It mainly focused upon the distribution of the governmental powers between the Canadian government and provincial government. And it didn't speak about the rights of the individuals, the rights of, the fundamental rights or the liberties of the individuals. Because Canadians were happy with, unwritten the Bill of Rights, like the United Kingdom. Canadians were happy with the unwritten the Bill of Rights. See, if you have a written Bill of Rights, you have a limited liberties. Your rights are confined to those rights which are expressly mentioned in the document itself. You take, for instance, in India, the Part 3 of the Constitution of India guarantees or enumerates the fundamental rights. Other than those rights which are expressly mentioned in the Part 3, it is very difficult to, be enforceable by the court of law. Your rights are limited. Your rights are confined to those rights which are covered by Part 3 of the Constitution of India. Then it is for the judiciary to interpret to say whether the particular right is protected by the part 3 of the Constitution of India or not. It is for judicial interpretation. It is for the judiciary to interpret it. And you cannot argue. If the right is specifically guaranteed, is specifically mentioned, so you can rely upon it. You can claim the enforcement of that right against the other state. So the Canadians enjoyed unwritten Bill of Rights. Unwritten the Bill of Rights, because the Constitution was silent. Constitution, they did not incorporate the written Bill of Rights or written Bill of Rights like Americans. Like Americans. This was the situation until 1960, 1960. After the Second World War, the Canadians realized that there was a need of written the Bill of Rights like America. Therefore, the people, they demanded the written the Bill of the Rights. As a result, the Canadian Parliament enacted a statute, what is known as Canadian Bill of Rights 1916. Canadian Bill of Rights 1960, 1960, which recognizes some of the basic liberties of the individuals. Basic liberties are, in other words, the human rights of the individuals. That is, the Bill of the Rights 1916. So it guarantees the freedom of speech, the freedom of religion, our right against arbitrary harassment and detention, our right to the properties, and other important the liberties of the individuals. And you remember, the Canadian Bill of Rights was not an integral part of the Constitution of Canada. It was a statutory instrument. The instruments, it was binding only the federal government, Canadian government. If your rights are violated by the Canadian government, you could invoke the Canadian Bill of Rights against the Canadian the government. If your rights are violated by the provincial government, you cannot claim. You cannot, enforce the Canadian Bill of, because the Canadian Bill of Rights was not binding on the provincial the government. Therefore, the Canadian Bill of Rights, they had a limited application and the scope. It applies to only federal government. The governments, if your rights are violated by the federal government, then you can invoke the Canadian the Bill of Rights. Canadian the Bill of the Rights. In 1982, the Canadian, the government amended the Canadian the Constitution, included in it a charter, what is known as Canadian Charter of Rights and Freedoms. Charter of Rights and the Freedoms. That is, in 1982. 1982. This is the constitutional instrument. Constitutional instrument which binds both the levels of a government, the Canadian government and the provincial the government. In the event of a violation of the rights guaranteed by the Canadian Charter of Rights and the Freedoms, so you can enforce your rights against the Canadian government and the provincial the government. The Canadian Charter of Rights and the Freedoms recognizes 5 categories of basic rights. 5 the categories. The first category of the rights is fundamental human freedoms. Fundamental the human freedoms. What are the fundamental human freedoms? Freedom of speech, the freedom of religion, freedom of the assembly, freedom of the movement. Fundamental, the human, the freedoms. Fundamental, the human, the freedoms. The second category is democratic rights, right to vote, right to contest for the election, or right to know the vote, or right to contest for the election. A democratic right, the guaranteed by the Canadian Charter of Rights and the Freedoms. Third category of right is mobility rights. Mobility rights. You have the freedom to move anywhere. Freedom of the movement, freedom of residence, freedom to earn the livelihood anywhere within the territory of the Canada. And fourth, the rights, the legal rights. Legal the rights, right against a double jeopardy, right against arbitrary arrest and the detention, a right against the self-incrimination, and right against cruel and unusual the punishment, and right to the translation, a right to legal counsel, and so on. These are the legal rights guaranteed by the Canadian, the Charter of Rights and the Freedoms. The last category is category is equality rights. Equality, the rights, right to equality is guaranteed by the Canadian, the Charter of Rights and other Freedoms. So there are three important documents. So far as the Canadian, the legal system, Canadian Constitution is concerned. Some of the rights are guaranteed by the Canadian Constitution. Some of the rights are guaranteed by the Canadian Bill of Rights, and some of the rights are guaranteed by the Canadian, the Charter of Rights and the Freedoms. So you have three documents which recognizes your human rights. Three documents. The Constitution Act of 1867, the Canadian Bill of Rights of 1960, and the Canadian Charter of Rights and the Freedoms, the 1982. Whereas in the UK, you do not have, the written Bill of Rights. You do not have written Bill of Rights because the UK has, the UK has, the adopted unwritten the Constitution. Unwritten the Constitution. It doesn't mean that there is no Constitution in the United Kingdom. Constitution exists in different forms. In the form of a statute, in the form of international treaties, in the form of a parliamentary convention, in the form of common law principles. Common law principles. Sometimes we mistake ourselves that the UK doesn't have a constitution at all. UK has a constitution not in a written form, but in an unwritten form. In the sense that the constitution of the UK exists in a different forms. In the form of common law principles. Common law, the principles. In the form of statutes. In the form of the statutes. In the form of a parliamentary convention. In the form of international treaties or the convention. International treaties or the convention. The UK follows the common law principles. The common law protects your liberties. Common law will safeguard your, the liberties, your fundamental liberties or civil liberties of other individuals. So in the event of a violation of any of your the basic rights, you can invoke the common law. You can invoke, the common law, which provides you remedy for deprivation of your the life, liberty, or the property, any other human rights, any other the human rights. And UK follows UGC-HR, European Convention on the Human Rights of 1915. So UGC-HR enumerates the human rights. Enumerates, the human rights of the individuals, life, liberty, property, freedom of speech, the freedom of, or the religion, all other human rights. You do come across with almost all the human rights in the ECHR of 1915. And the UK Parliament has adopted Human Rights Act in 1998. 1998 Human Rights Act of 1998, which incorporates almost all the rights embodied in the ECHR of 1915, European Convention on the Human Rights. So the Human Rights Act of 1998 recognizes the human rights, recognizes your the human rights. So in the event of a deprivation of any rights, so you can invoke the Human Rights Act of 1998. So there are the three methods of a guaranteeing of basic rights. Three methods of guaranteeing of the basic rights, or the basic rights in the sense that human rights: constitutional method, common law method, and a division of powers, the method. Constitutional method, your rights are incorporated in the Constitution itself. Your rights are protected by the constitutional instrument itself. That is constitutional method of guaranteeing of your basic rights, guaranteeing of the human rights. Whereas in UK, your human rights are protected by the statutes. Protected by the statute. Therefore, it is called common law method of a guaranteeing of the basic rights. Common law method of guaranteeing of the basic rights. So your rights are protected by the statutes. Your rights are protected by the common law. Whereas in the United States of America, your rights are protected by the Constitution. In India, our rights are protected by the Constitution, Part 3 of the Constitution. Whereas in the United Kingdom, the basic rights, the human rights, are protected by the common law method. Protected by the common law, the method. Whereas in the Canada, your rights are protected by division of powers, the method. Division of the powers, the methods. The federal, the Canadian government and the provincial governments, that protects the rights, the basic, the rights are the liberties of the individual, liberties of the individuals. So this is the brief, the background of the Constitution of the US, UK, and the Canada, wherein you come across with the basic recognizing the basic rights and the liberties of the individuals. Now let me focus on a specific right to life and liberty. Right to life and the most important liberty of the most important right of the individuals. If you look at the Article 21 of the Constitution, yes, you do come across with right to life and the personal liberties. And if you look at even American Constitution, you do come across with express provision which protects your right to life, the liberties. If you read the 5th Amendment to the Constitution and 14th Amendment to the Constitution of US, you do come across with the protection for your life, the protection for right to life, liberty, and the property of the individuals. The 5th Amendment to the Constitution of US guarantees that no person can deprive the life, liberty, or the property without a due process of law. So your right to life, your right to liberty, right to property cannot be taken away without a due process of law. Similarly, 14th Amendment guarantees right to life and the liberty and the property. See, what amounts to life? That is the very important question. We have been, the talking of the human rights in the last 1 week. Now the question is, when does right to life begin? When does right to life begin? Is it after the birth? Or is it, is it after the birth, or could you say that, right to life begins when a fetus is conceived in the mother's womb? That is the question. In English law, there is a case, R versus Paton, PATON, wherein the question was whether right to life begins with the birth or the moment the child is conceived in the mother womb, or fetus is, the conceived in the mother womb. In this case, the court have this very, very important, so perhaps the beginning of the human rights. The English court observed that right to life begins with the birth. Right to life begins with a birth. A fetus cannot claim right to life. A fetus cannot claim because fetus is not recognized the person. Therefore, the court, the English court observed that right to life begins with birth. The same question arose for the consideration of the Supreme Court of Canada in R versus Marsden Taylor. R versus Marsden Taylor. The Supreme Court of Canada observed that right to life begins with a birth. Right to life begins with a birth. And even American court, in a leading case, Roe versus Wade, ROE versus Wade, the American Supreme Court observed that right to life begins with a birth. Begins with the birth. So birth is, a factor for climbing the fundamental liberties, a factor for climbing, the human rights of other individuals, the human rights of other individuals. And you do find, the word liberty. We have liberties. We have, the liberties. So here, what form of liberties we have? Economic liberty, or personal liberty, or physical liberty. Physical liberties. The Canadian, the judiciary has made it very clear that the word liberty is confined to only physical liberty. Physical liberty, freedom from wrongful arrest, freedom from, wrongful arrest and wrongful confinement, the freedom from arbitrary arrest and the detention. That is, the freedom relating to the body. So here the Canadian, the Constitution, or the Canadian, the Supreme Court has recognized physical liberty, the liberty. And UK court has also recognized only the physical liberty. You cannot claim economic liberty. You cannot claim any other, other the liberties except, the physical, the liberties. Whereas the American, the Supreme Court has observed that the word liberty includes not only physical liberty, but also economic liberty. Economic liberty. So you have, the physical liberty, which includes freedom from wrongful arrest, freedom from arbitrary arrest and the detention, the freedom from wrongful the confinement, or freedom from, the arbitrary arrest and the detention. economic liberties. You have the right to work, right to employment, right to earn your livelihood, right to earn your livelihood, and you have the other the freedoms they as well, other they as well. Now here the question is whether right to life includes privacy right. Privacy right. Can you claim you have the privacy rights, or the privacy right as a fundamental right guaranteed by the American Constitution? See, this question arose for the consideration of the Supreme Court of the United States in a leading case, Roe versus Wade, whether the right to life and liberty includes privacy rights of other individuals. In Roe versus Wade, the question was whether the liberty includes liberty to terminate pregnancy. Here there is a 18-year-old, the girl, who wanted to terminate her pregnancy, but it was an offense under the statute. Statute prohibits termination of a pregnancy, whereas the 18-year-old girl argues that it is her right to terminate the pregnancy, and it cannot be taken away by the state. And this is the 18-year-old girl argues that life includes, the liberty includes liberty to terminate the pregnancy. The court observed that yes, it's the liberty for the woman to terminate her pregnancy. So the court recognized right to terminate the pregnancy as a protected right. The protected the right. So here the privacy includes the right to privacy includes the right to terminate one's the pregnancy, right to terminate one's or right to terminate the pregnancy. It is the freedom of the woman to terminate her the pregnancy. Whether your privacy right includes freedom to talk in private. In a case called Cards versus United States, Cards, KATZ versus the United States, wherein the investigation agency installs an electronic device to record the conversation of the petitioner, the petitioners. So even in this case, the Supreme Court of the United States observed that privacy right includes privacy of talk, and it cannot be secretly recorded by the investigation agency, because it is the liberty which is protected by the 14th Amendment to the Constitution of the US. Constitution of the US. So right to privacy is a right protected by the 14th Amendment to the Constitution of the US, Constitution of the US. In another case, what you R versus Windsor. R versus Windsor, wherein the question was whether same-sex marriage is a recognized the right recognized recognized or protected by the American the Constitution. In R versus Windsor, the Supreme Court of the United States observed that the same-sex marriage is permissible. Same-sex marriage is the permissible because it is the liberty of the individual to choose any sex as a life partner. The state cannot prohibit the same-sex marriage. Same-sex marriage or same-sex marriage. So in R versus Windsor, the Supreme Court of the United States recognized same-sex marriage. In 2018, the Supreme Court of the United States in Obergefell versus Hodges, the court recognized the rights of LGBT, rights of the LGBT. So LGBTs have the fundamental rights or the liberties guaranteed by the American Bill of Rights or 14th Amendment to the Constitution of the US. In another case, Loving versus Virginia, a very interesting case this is. Loving versus Virginia, wherein the question was whether the state can prohibit interracial marriage. State has prohibited interracial marriage. So white cannot marry a black woman, or the white woman cannot marry black man. So Virginia state has enacted a legislation which they prohibited the interracial marriage. Interracial marriage is a crime. Just like in India, where you come across with prohibition of interreligious marriage. Interreligious other marriage. So here the question is whether privacy includes the freedom of a marriage, irrespective of race or the color. The Supreme Court of the United States struck down the interracial marriage as, the prohibition of the interracial marriage as unconstitutional. The privacy includes the freedom of the marriage. So it is the choice of the marriage is your, other choice. The state cannot interfere with this, the freedom. In another case, the state provides for compulsory sterilization. Compulsory sterilization. Whether it violates your right to life or the liberty guaranteed by the the Bill of Rights or 14th Amendment to the Constitution of US. So in this case, in the particular case, the Supreme Court of the United States observed that compulsory vaccination violates the liberties of the individuals. The liberties of the individuals. So in all these cases, you do come across with how the Supreme Court of the United States respected the human rights of the individuals. So human rights are the very, very important aspect of the individuals. Therefore, they cannot be violated by the state or its other agencies. With this, I conclude my brief talk about the recognition of human rights or incorporation of human rights in the Constitution of US, UK, and the Canada. And if you have any questions, you are free to ask me. Hello.
Sir,
Yes, please.
good morning. One of the wonderful presentations, sir. I witnessed one of the brainstorming presentations from your side, sir.
Okay.
Sir, can that unique Aadhaar card,
Pardon me?
that Aadhaar card, sir, Aadhaar card that the
Yeah.
government of India made a unique and uniformal Aadhaar card to each and every citizen of our country.
Yes.
Sir, whether it won't violate our right to privacy, sir.
Yeah.
Takes our fingerprints and high risk record and,
Yes,
and
yes,
everything,
yes.
almost all data. Is
Yes.
it violates right to privacy?
Yeah. It's very the pertinent question, the which concern to the research project itself. Just the 6 months ago, I submitted a minor research project on the impact of Aadhaar card on privacy rights. It's the minor research project, the wherein I discussed the impact discussed the impact of Aadhaar card on the privacy rights guaranteed by the Indian Constitution, in particular Article 21. So far as a judicial approach is concerned, there are two important case laws. Karak Singh are the case and the Sarma's case, wherein the Supreme Court was not so clear about the privacy right, whether it is protected by Article 21, whether it is the right to privacy is covered by the personal liberty of the individuals. So the approach of the judiciary was not so clear. Whereas in the case Puttaswamy's case, Justice case Puttaswamy's case, the Supreme Court of India made it very clear that privacy right is protected by Article 21. It's an integral part of, it's the fundamental right, guaranteed by Article 21. Now the question is whether Aadhaar card violates the privacy rights of the individuals. Privacy rights of the individuals. You have to provide all your personal data. And it is a must if you want to avail any benefits from the government, even if you want to open a bank account, or if you want to join the child to the school, you have to produce your Aadhaar card. So here Aadhaar card involves the personal data, personal information of the card holders, our names, our family details, the marriage details, telephone numbers, the bank account details, and our all of the personal information. So here, so according to the research, the findings, I have mentioned that Aadhaar card violates privacy rights of the individuals. In my empirical studies, majority of the respondents were not aware of this fact. I interacted with around 300 the respondents within the Mysore district, and nobody knows the Justice Puttaswamy's case. And even if you avail the telephone, if you want to buy the SIM card, and you provide the details of your Aadhaar card, it's a great violation of privacy rights of the individuals. The government cannot make it the mandatory. Of course, it was initiated for the purpose of the preventing misuse of the government beneficiaries or the welfare schemes of the government, but it violates privacy rights of the individuals. It's against Justice Puttaswamy's case, wherein the Supreme Court has observed that privacy right is a fundamental right. It violates the Aadhaar card, violates your fundamental rights. Instead of the Aadhaar card, the government can bring out citizenship card. Why should the government insist on Aadhaar card? The Aadhaar card cannot be made mandatory for availing the benefits. It should be made the optional. So one of the findings was Aadhaar card should be made optional rather than mandatory. If it is a mandatory, it violates the privacy rights of the individuals. And this Aadhaar card is, the inconsistent with the Supreme Court ruling in Justice Puttaswamy versus Union of India. Hello.
Thank you, sir. Thank you, sir. Thank you.
Sir,
Yes, please.
nice presentation, sir. Sir, I just want to know, of late we have been using biometric thing and fingerprint for attendance and all in institutions.
Yeah.
Does it amount to violation of privacy?
Yeah. See, in many of education institutions, you do come across with the installation of a CCTV, biometric. Strictly speaking, it violates the privacy rights. There are other methods